I see Mr. Finn and Ms. Zachary. I think that means we're ready to call the final case for today's case call, which is Hunt versus Empire Fire and Marine Insurance Company. And we will start. You each have 15 minutes, and we will start with the appellate.
Should that be the cross appellant, Your Honor?
Yeah, I guess so. I was just trying to figure that out as I was looking at my notes. I think so.
Thank you very much.
Yeah.
Andrew Finn on behalf of the plaintiffs and Sergeant Trucking. Also, Drew Jordan is participating via the link. He's a co-counsel on this case with me. Basically, Your Honor, this case started in 1996 and 1997, these three cases, I should say. When they were served, the Drielick defendants tendered their defense to their insurer, Empire Insurance Company. Empire declined to defend and declined to participate in settlement negotiations. On March 14, 2000, the parties entered into settlement, including the Drielicks. Consent judgment were entered against the Drielicks in all three cases. Later, in December 2000, the plaintiffs filed applications for writs of garnishment against Empire. For the past almost 20 years, and I guess 19 years and 2 months, the only issue that's been litigated in this case has been Empire's liability under its policy of insurance for the Drielicks' liability. Recently, the Court of Appeals affirmed the ruling that that Empire was obligated to to indemnify the Drielicks. Empire filed an application for leave to this court, which was denied as part of the application that resulted in this cross application. So now it's been conclusively established that Empire had the obligation to, sorry, I'm having a hard time being on the Zoom here, that Empire had the obligation to indemnify the Drielicks. The only issue today is whether Empire is responsible for interest that accrued over those last 20 years under 600.6013. I'd like to first start with the premise that MCLA 600.6013 is a remedial statute. It's intended to be liberally construed in favor of the plaintiffs, and that's the Denham case and Coughlin versus Dean. Both of these cases are cited within our brief. The purpose of the statute, as those cases set forth, is to compensate the prevailing party for the expenses and delay in receiving such damages. As I mentioned earlier, there's no question that the plaintiffs are the prevailing parties in these cases. There's basically two bases for imposition of prejudgment and post-judgment interest on Empire. Empire, first of all, does not dispute the obligation of paying interest from the date of filing through the date of the entry of the consent judgments. So we're really looking at three separate periods that are in dispute. The period between the date of the consent judgments and the filing of the applications for writs of garnishment. And also the second period would be from the dates of the garnishments through the entry of judgment in the trial court. And then Empire is also currently contesting the obligation to pay post-judgment interest against it as a party on the judgments entered against it back in, I believe, 2016 now. First of all, Empire argues that the language of its policy relieves it from the obligation to pay post-judgment interest on the consent judgments because that only operates in cases in which they defend. However, the only reason they didn't defend is because they were in breach of their obligation to defend. So what they're trying to do is take 20 years of interest and keep that that arises solely out of their refusal to defend the case that they had the obligation to defend. This was the issue that was before the court in Sederholm versus Michigan Mutual, 242 Mishap 372, which we cited in our brief. Similarly, the insurer in Sederholm reached its obligation to defend. The insurer was found to be liable for both pre and post judgment interest because basically the court said you can't profit off of not defending, even if you're your refusal to defend was made in good faith.
Mr. Finn, let me interrupt you and just make sure
Yes.
my colleagues who have questions can ask them, and we can come back to you if nobody has them. Justice Kavanaugh's not participating in this case. I should have said that at the start, so I'll start with you again, Justice Markman.
I have no questions. Thank you.
Justice Zara?
No questions, thank you.
Justice Viviano?
Counsel, did your client ever tender the defense of this case to Empire?
The Drielicks did, the insureds did. And there's, we did cite that testimony in the application and in the supplemental brief. Mr. Drielick tested.
And what was the result? They denied to come in and
They
defend the
denied.
case?
They denied the defense, yes.
And was that issue ever litigated?
Not the defense, no. The Drielicks negotiated a settlement with a covenant not to execute against their personal assets and only to execute against the insurance policy, and that's how we end up here today.
And how does that bear on your position? How can you rely on the failure to defend if it wasn't litigated?
We under the basic premise of Michigan law or insurance law is the duty to defend is broader than the duty to indemnify. If there's a duty to indemnify, as there clearly was in this case, a fortiori, they must have breached the duty to, they must have had a duty to defend. And the duty to defend is one that they did not accept.
Okay, thank you, Counsel.
Very good.
Justice Bernstein?
No questions.
Justice Clement?
No questions.
Counsel, you may continue, or if you want to reserve your time, you can do that and see what happens.
But I guess the only other question I had then would be whether it's necessary to address the other argument, which is Empire's liability for judgment interest as a party once they became a party to this suit in 2000 when the writs of garnishment or the applications for writs of garnishment were filed.
I can't advise you what to do, but why not? You have the time. Why not address it?
All right, I'll address that very, very briefly. First of all, with respect to that issue, I know Empire has raised the issue as to whether or not we had an obligation to file an application for to file a cross appeal of that issue in the Court of Appeals. The court in the trial court said that he was not going to accept that argument, but he accepted the alternative argument, which was that they owed prejudgment interest. And there's plenty of case law. I've cited cases in our briefs. There's also Supreme Court case law, Taya versus Oregon Procurement Agency, 498 MISH 68, that says basically you don't need to cross appeal an alternative ground for the relief granted. You only have to cross appeal if you're seeking relief that goes beyond that granted by the trial court. And we did not have, we are not seeking relief beyond that granted by the trial court. So we did not have an obligation to pursue that issue. With respect to, I'm sorry, we didn't have an obligation to pursue that as a cross appeal. With respect to Empire's liability as a party, MCLA 600.613 provides for interest on a money judgment in a civil action from the date of the filing of the complaint. The court rules, specifically MCR 3.101, provide that garnishment proceedings are civil actions, and I've quoted that in our brief. The civil action begins with the filing of the complaint is deemed to be the application for writs of garnishment. I've cited several cases, Hayes versus Ross, and cases from around the country in which courts have held that yes, absolutely, when a party, whether it's an insurer or any other party, contests a garnishment action, and it goes on like this one did for 20 years or even less, it doesn't matter. The garnishee defendant is responsible for judgment interest as a party. And with that, I'll reserve the remainder of my time. Thank you.
You bet. Ms. Zachary.
Good afternoon. May it please the court, Nicolette Zachary on behalf of the garnishee defendant Cross Appellee Empire Fire and Marine Insurance Company. Just to start, I believe that Empire takes position that the application for leave to cross appeal should be denied, and that the Court of Appeals ruling on the judgment interest issue should be affirmed. Few points of distinction that need to be made here is that there are two periods, distinct periods, applicable for purposes of judgment interest. There is a pre-judgment interest period and a post-judgment interest period in this case, and that is based on the trial court's ruling below, which has not been challenged on appeal, that the only complaints that are relevant for purposes of determining judgment interest are the original underlying complaints in the personal injury actions from 1996 and 1997. So the first period is from the 1996-97 complaints to the date of the underlying consent judgments against the defendants, the Drielicks, who are the Empire insureds, that were entered on March 14, 2000. From any period after that, from March 14, 2000 forward, is post-judgment interest. I also want to make the point that, and the Court of Appeals held that based on the terms of the policy and the Matich case, that Empire, pursuant to the terms of its policy, did not have an obligation to pay judgment interest in excess of its policy limits. And I think that that's an important distinction because it did not defend the underlying suit. And that does bring me to the separation of issues between a garnishment proceeding, which is an ancillary proceeding by a judgment creditor. So the issue that is pursued in a garnishment proceeding is what, if any, obligation the insurer has to provide or pay coverage for a judgment against its insured. It does not have to do with a breach of a contractual duty to defend. And in terms of the assignments taken from the Drielicks, as the Court of Appeals noted, in their opinion, the contractual duty to defend is owed to the insured and not to a judgment creditor. And they could have filed, having taken that assignment from the Drielicks, could have filed a separate declaratory action on breach of contract for an alleged breach of the contract duty to a defender under the insurance contract. They did not do that. And that was still a viable claim when the March 14th, 2000 consent judgments were entered against the Drielicks. The earliest date that would have expired would have been sometime in 2000 based on a 1995 insurance policy. I don't know if that goes 6 years from the date of the policy or from the date of the alleged breach. Whatever it is, the 6 years has long since passed, but it was still viable when these judgments were entered. So in this case, going past that issue, what we're really dealing with is the Matich case is a Supreme Court case. I believe that it controls the policy. The Empire policy in this case has different language than the policy that was issued in Matich. It does expressly limit liability for post-judgment interest in excess of policy limits to suits that Empire defends. And I believe that it's plain unambiguous and should be enforced as written. There are a couple of things that garnisher plaintiffs, well, before I go on to that, in part that's based on a well-settled principle that an insurer is permitted to contractually limit the risk it assumes. And that case law is cited in my briefs, the Cottrell case, the Westchester case, Cosby case, and also Matich references that are as well as Auto Owners versus Churchman, 440 Mish 520.
Zachary, why don't I interrupt you here and see if my colleagues have questions, okay?
Okay.
All right, Justice Markman?
Yeah, I guess I would just like to ask, what I think is a fairly straightforward question. How do you respond to the cross appellant's argument that MCR 3.101 indicates that a garnishment proceeding is a civil action like any other that results in a judgment independent of the underlying action and therefore triggers judgment interest under the law?
Well, I'm glad you asked me that, Justice, as I do want to address that. As I said earlier, a garnishment proceeding is an ancillary proceeding, even under MCR 3.101. So that kind of harkens back to the trial court's ruling regarding the only relevant complaints are the original complaints. While the garnishment court rules indicate that the writs of garnishment would be treated as a complaint for purposes of how the garnishment proceeding continues once the writ of garnishment is issued and objections have been filed. It does not speak to starting a new prejudgment interest period. And I would also like to point out in MCR 3.101, there are multiple areas in that court rule, subsection G, where it references G2, which represents liability of the garnishee, makes reference to the garnishee is liable for no more than the amount of the unpaid judgment, interest, and cost stated in the verified statement requesting the writ of garnishment. The unpaid judgment has to be separate from, is talking about the judgment against the underlying defendant, the insured, not a judgment against the garnishee. And so it's already contemplated the prejudgment interest, but it does not talk about new interest period starting against the garnishee defendant. I also would point to MCR 3.101 subsection O1, where it again talks about judgment and execution. Judgment may be entered against the garnishee for the payment of money or delivery of specific property as the facts warrant. A money judgment against the garnishee may not be entered in an amount greater than the amount of the unpaid judgment against the defendant. I'm adding that word because that's what it's contemplating. Interest and cost stated in the verified statement requesting the writ of garnishment. So based on those, I would, and the law cited and the articulate assessment of the Court of Appeals on this issue, there are only two periods. There's the underlying original complaints to the date of the contempt judgments against Drielick, and then that period forward is all post-judgment barred by the terms of the Empire policy.
Well, Ms. Zachary, can I follow that up? I understand there are decisions that suggest that the garnishment proceeding is an ancillary proceeding. You've used that term, and I acknowledge that there are cases to that end, although none seem on all fours with this case. But as I look at the court rules, nonetheless, the relevant court rules, I see on at least 3 or 4 occasions language along the line that garnishment proceedings are to be treated like, quote, other civil actions. What should I draw from that kind of textual clue?
Well, other civil actions, it does say that in terms, like I said, in terms of procedurally how you proceed once the writs of garnishment and the objections have been filed, that then yes, it does proceed like other civil actions in the respect of addressing the issues at hand. But again, it still brings it back to it being an ancillary proceeding, and it doesn't, based on, like I said, the express language of the court rule doesn't say that there is a new period, that the writs of garnishment are a new complaint for purposes of determining judgment interest. This is a proceeding by a judgment creditor to collect on a judgment against a defendant who is the insured of the garnishee defendant. So that liability is established, and that's the only issue is what is owed for payment of that judgment. So the judgment interest is judgment interest being assessed against the underlying defendant, and that's what is at issue in the garnishment proceeding. It does not open it
Not
up
to give you a
more.
hard time, but I also look at the MCL 600.6013 and the statutory requirements that are set out in that provision for judgment interest. And then I look at the garnishment proceeding, and I'm not an expert in the proceeding, but it seems like it's fundamentally brought to enforce a private right, which is one of the requirements, to payment from a third party who has a debt. And it commences with the filing of a writ of garnishment, which is another element of 6013. And it may result in the entry of a final judgment, which is still another explicit requirement of 6013. Is there something in 6013 that's missing from the fundamental nature of the garnishment proceeding?
Well, Your Honor, respectfully, yes, I would say that there is. That the under 66013, the references, I believe that the references that you're making to writs and such, they're not talking about, there's no express reference to garnishments in that judgment interest statute. It is explicitly talks about money instruments and things of that nature. The fact that it's a garnishment to collect insurance proceeds does not transform this into a money instrument that they're trying to collect on. And that's where I think the disconnect is between when you look at it all together and the precedent of Matich, that there is no new period that starts. And again, I would still respectfully say that this argument is really trying to do an end run around the trial court ruling below that the only relevant complaints for purposes of judgment interest in this case are the original 1996 and 1997 complaints. That ruling was entered back in an order in January 28, 2016. That was not one of the orders that was appealed by Empire in the Court of Appeals. The issue that was appealed by Empire was whether the terms of the policy bar the post-judgment interest, not what the post-judgment interest period was. And I think that that is a distinction that precludes this argument that garnisher plaintiffs are making regarding the writs being new complaints, because that was addressed by the trial court in detail. The trial court rejected that proposition, and it was not appealed.
Would I be fundamentally misunderstanding 6013 if I were to understand it as trying in a very rudimentary way to define what constitutes a civil action in which judgment interest would be appropriate?
I'm sorry, could you repeat that, Justice? I didn't quite get what you were saying.
I was just wondering if I would be fundamentally misunderstanding 6013 if I viewed it as a fairly rudimentary way of attempting to define what constitutes a civil action for purposes of judgment interest.
I think that it cannot be evaluated solely by itself in a vacuum, so to speak. We have to take all of the statutes and court rules and the case law that are at issue here and taken together. And I think when you take all of that together, it does not create it does not support the proposition that there's a new prejudgment interest period that starts when the writs of garnishment are issued. The case law, and I will point to, I only have a few moments left, but I will point to, and I understand it's a federal Eastern District case, so not necessarily precedential, but Key Safety Systems, Inc. versus AIG Specialty Insurance Company, 2017, Westlaw 3085485, which is cited, 2017, cited in my supplemental brief, makes a clear distinction between what a judgment is and interest is. And I think that's the distinction that is important here, is that our liability for the judgment is what it is post-judgment interest is determined by the policy based on the trial court's ruling that the only relevant complaints are the original ones. So the post-judgment interest period started March 14th, 2000, and there was no renewal of a pre-judgment interest period.
Could I ask you just one final question in this regard? In light of what seemed to me to be some of these rough textual clues in this context, and my recognition, as I think I said at the outset, that there are cases that do describe this as an ancillary proceeding, although such cases don't seem very helpful since most of them don't go very deep into the analysis. But is there a particular case that characterizes the garnishment proceeding as an ancillary proceeding that you would call my attention to, or this court's attention to, for the strength of its argument in support of that conclusion?
Well, Your Honor, I believe that there's three cases that I mainly cited to: the Grand Trunk Western Railroad case, which is 461 Mish App 117, the Ward versus DAIIE 115 Mish App 30, which is a 1982 case, and then there's an unpublished case which relies on Ward, which is Schultz versus AAA of Michigan. And while it's not a binding precedent, it relies on the Ward case, which is a published decision in addressing this issue of it being an ancillary proceeding. And I think those three cases together support Empire's position in this case.
Thank you, counsel. Appreciate it.
Justice Zara?
No questions.
Justice Viviano?
Oh, sorry, no questions.
Justice Bernstein?
No questions.
Justice Clement?
No questions.
Okay, Mr. Finn, you have some rebuttal time.
Sorry about that, I was muted there. I just have a couple of things that I will address with the rebuttal. First of all, with respect to the issue of whether this is an ancillary proceeding, and if so, that means that we only look at one date for the filing of the complaint. I would then draw the court's attention to the Rittenhouse versus Earhart case, which says, for purposes of prejudgment interest, we look at the filing date, and even if somebody is added years later, they're responsible for prejudgment interest from the date that the case was filed. So for in this instance, Empire became a party through an ancillary proceeding, if you want to call the garnishment an ancillary proceeding, in December 2000, but they're responsible for interest going all the way back to the original filing dates. So that's one way to address that. I also want to mention that in the Grand Trunk case that was just cited, the court did award interest on the garnishment. The plaintiff sought interest at the 12% contract rate, and the court said, no, you get interest, but you get interest at the regular tort rate. So that's what the Grand Trunk case did. Finally, I want to just address real quickly the Maddox case. In that case, the court did award interest against the insurer, post-judgment interest against the insurer that did not defend the case, and that was the excess insurer, INA. And in INA's policy, which they quote actually in the dissent, it wasn't quoted in the case itself, INA obligated itself to pay all costs in any suit defended by INA and all interest on the entire amount of any judgment therein. Well, what is therein? Therein is any suit defended by INA. That's what that refers back to. So what the court did was basically awarded interest against the insurer, post-judgment interest, for the insurer that did not defend, even though the policy required or the policy stated that judgment interest would only be awarded in cases that they defended. And unless there are any other questions, that's the extent of my rebuttal.
Are there any additional questions for Mr. Finn? Okay, the case will be submitted. Thank you both. And that concludes today's case call. We will be back here tomorrow morning at 9:30 with more cases.